Thank you so much, Professor Lydon. I think that was really interesting to have the sort of two-scale view of what's happening in ASEAN, and also appreciate you raising the issue of transboundary issues and transboundary risk, which I think if we have time would be interesting to discuss further. It has such resonance in the Hindu Kush Himalaya, but thank you very much for all of those insights. And last but not least, we will turn to the final speaker of the Paro Forum, who is Professor Michael Gerrard, who is the Andrew Sabin Professor of Professional Practice at Columbia Law School, where he teaches courses on environmental and energy law and founded and directs the Sabin Center for Climate Change Law. He's also a member and former chair of the faculty of Columbia's Earth Institute and previously practiced environmental law in New York City full-time for nearly 30 years. He has been ranked as the leading environmental lawyer in New York and among the leading environmental lawyers in the world, and he will tell us about the North American experience. So over to you, Professor Gerrard.
Thank you very much. I wish I could be with you in person, but I'm happy to be with you remotely. One of the major activities of the Sabin Center for Climate Change Law, which I founded and direct, is creation of a number of databases about climate change law in the U.S. and globally. And I'm going to talk about the experience particularly in the U.S. in the context of those, or with the frame of those databases. Let me share my screen here. Can you see that?
Yes, we can.
Yeah, so one of the key facts about climate change law in the U.S. is the partisan divide between the Democrats on the left and the Republicans on the right. This chart derives from studies by a group called the League of Conservation Voters, which rates different members of Congress by their votes, whether they are basically pro-environmental or anti-environmental. And we see in red are the votes by the Republican members of Congress. In solid are the House, and dashed in the Senate, and these are the Democratic members of Congress. Basically, all of the major U.S. environmental laws were enacted between 1970 and 1990, and there was always a gap in the views of the Democrats and the Republicans, but it was a gap that could be bridged. And so the major environmental laws were enacted during this period, culminating with the Clean Air Act amendments in 1990, which have formed most of the legal authority for a lot of what the U.S. has done on climate change. Since 1990, for various reasons we don't have time to get into, that partisan gap has widened and has become unbridgeable. And as a result of that, we do not have any framework legislation on climate change in the United States. We don't have any legally binding targets. The targets are all adopted by the president, and whenever and his administration, and whenever party control of the White House changes, the federal policies change radically. So President Clinton, a Democrat, favored action on climate change. President George W. Bush opposed most of it and stopped federal action. President Obama, a Democrat, then during his 8 years had the government move solidly in favor of climate change action, but he was unable to get enough votes in Congress to enact framework legislation. President Trump, a Republican, then worked to revoke most of what had been done in the Biden and the Obama administration. And now President Biden, a Democrat, is revoking most of what President Trump did and trying to move beyond. So we have a real lack of stability here, and that makes it difficult to build up the momentum that we need to have a coherent system of climate regulation. A surprising and positive event occurred last August with the enactment of what was called the Inflation Reduction Act. It wasn't really about reducing inflation. It was largely about devoting a great deal of federal money to the clean energy transition. President Biden's initial plan was for an even larger bill that would include climate regulation in many ways. But the U.S. Senate is split 50-50 between the Democrats and the Republicans, which meant that every Democratic member of the Senate essentially had a veto. And one of the Democratic senators, Senator Joe Manchin, is from West Virginia, which is a coal state, and he managed to block the more aggressive portions of that bill. But ultimately, the bill passed. Senator Manchin supported it. The tie was split by Vice President Kamala Harris, who's a Democrat, and the Inflation Reduction Act was enacted without a single Republican vote in either the House or the Senate. The Inflation Reduction Act accomplishes quite a bit. What this chart shows is U.S. greenhouse gas emissions. Now, they've been declining, mostly because hydraulic fracturing has made available a lot of inexpensive natural gas that has displaced a lot of coal for generating electricity. We've also had stronger motor vehicle standards and energy efficiency measures, but this is what has happened to greenhouse gas emissions in the U.S. President Biden has declared a Paris target a reduction of emissions by about 50% by 2030, leading to an aspiration of net zero by 2050. Before the Inflation Reduction Act, this is what the emissions would have been projections of business as usual. With the Inflation Reduction Act, projection is down here, and that is mostly because that new act will finance the construction of a massive amount of solar and wind and transmission and so forth. There is still a significant gap to get to President Biden's target. And that requires other action. So, as I mentioned, we have many databases at the Sabin Center, and I'll talk a little bit more detail about some of them, but we have a database that attempts to capture all of the climate change litigation around the world. When President Trump was inaugurated, we launched something called the Climate Deregulation Tracker to keep track of his administration's revocation, his elimination of many of the regulations that had been adopted under President Obama. And then when President Biden took office, we renamed it the Climate Re-Regulation Tracker to keep track of the regulations that the Biden administration was putting back in. The model laws for deep decarbonization database posts many actual and model laws that mostly states and local governments can adopt. We have a climate attribution database showing how certain kinds of climate events can be attributed to climate change. The Trump administration was working very hard to deny climate science and silence scientists. We kept track of that in conjunction with a group called the Climate Science Legal Defense Fund. A great deal of work has to be done to remove carbon dioxide from the atmosphere, so we're keeping track of the relevant laws. And New York City and New York State have their own laws on climate change. We also maintain a number of free mailing lists that anyone can sign up to keep track of all of these things. So with respect to climate change litigation, we've divided it between U.S. cases and cases in the rest of the world. And to help keep track of the cases in the rest of the world, we have put together about 100 rapporteurs, 100 people from around the world who help keep us informed of the litigation that is happening outside of the United States. Now, in all, we've identified, this was as of April, the number is higher now, 1,994 climate cases around the world, of which the United States has 72%. We are by far the champion, if you call it that, in climate change litigation. Australia is a distant second, and the UK is a distant third. But in all, there's litigation happening in about 40 countries around the world and several international tribunals. And that number is growing constantly. So it's really a global phenomenon. In the United States, the largest number of cases is under the National Environmental Policy Act, NEPA. That's our environmental impact assessment law. NEPA is procedural. It's all about disclosure. It does not have substantive requirements, but NEPA is often invoked in challenges to actions whose opponents think that there has not been enough environmental review of the action before the government took the decision. The states are also able to adopt their own environmental impact assessment laws, and California in particular is the subject of a great deal of litigation under its environmental impact review law. The Clean Air Act, as I say, is the principal federal law with a substantive bite, and it has played a central role when President George W. Bush, when his administration was refusing to act on climate change. The state of Massachusetts and others sued. EPA was saying that it did not have the authority under the Clean Air Act to regulate greenhouse gases. The case went to the Supreme Court, and in a landmark decision in 2007 called Massachusetts versus EPA, the Supreme Court said that EPA does have the power to regulate greenhouse gases, and that empowered President Obama, who came in 2 years later, to use that authority. Whatever the Obama administration did under the Clean Air Act was then challenged in court, and so many of these lawsuits were brought by industry and by the states that oppose action on climate change. Under President Biden, there's been additional litigation, and over the summer, the Supreme Court limited the authority under the Clean Air Act in a case called West Virginia versus EPA. We've had a few cases seeking money damages from fossil fuel companies, similar to the Lua case in in Peru that we just heard about. There are about 25 of those cases pending. None of them have advanced very far. They're still pending because of procedural issues about whether they belong in state court or federal court. These are mostly cases brought by states and cities against the major oil companies, but they are still held up on this procedural issue. There have been a few very prominent cases under the public trust doctrine, most famously a case called Juliana. It has not succeeded. It has some similarities to the Urgenda case that Professor Scotford mentioned, but none of those cases have really succeeded either. The cases that have been successful so far have been those under federal statutes as opposed to under constitutional theories or common law theories or public trust theories. The model laws for deep decarbonization database arose from a book that I co-edited called Legal Pathways to Deep Decarbonization of the United States that had about 1,100 recommendations for federal and state and local law to reduce greenhouse gas emissions. One particular aspect of U.S. law is that, especially since we don't have a federal framework law, that the states have tremendous power here. Each state has tremendous powers, and in many states, the cities have their own powers. And it varies much from one state to another, one city to another, but we've created this database with model laws that states and cities that are interested in adopting climate change laws can adopt. I mentioned the climate re-regulation tracker. I only have a couple of minutes, and let me mention the actions in New York State and New York City. One thing that was striking about Professor Lin's presentation is that New York City is very similar to Singapore in that we have similar population sizes, similar land area, similar reliance on other areas for most of our resources. However, unlike Singapore, New York City, of course, is not a country. It's a city within a state and a state within a country. And so it has limited autonomy. But New York State has adopted an important climate change law, and New York City has adopted another important climate change law. These laws are very ambitious, but implementation of them is a significant challenge. There are many deadlines built into these laws, and so we track the implementation of the requirements. I would say that the single biggest part of these laws and the single biggest challenge is the construction of an enormous number of new wind and solar facilities and transmission lines. Because of our legal structure, local governments, towns and cities, ordinarily need to approve these. Some of these projects get a lot of local opposition. The New York State law now allows the state to override local laws, local zoning laws that would block these projects. It's politically difficult to exercise that authority, but we are tracking all of that and trying to encourage the construction of these renewable energy facilities. The final thing that I'll say is that we've formed something called the Renewable Energy Legal Defense Initiative, which provides pro bono legal help to communities that want wind and solar, but that are facing local opposition. So this is a problem not only in New York. The implementation of the Inflation Reduction Act may face some impediments because of local opposition, as well as because of difficulties with supply chain, with workforce, with other issues. So we now have in the United States a great deal of money available for the energy transition. We hope that we are able to utilize that money effectively, but we need additional regulatory action and other actions in order to get all the way to meet our objectives, and litigation will continue to play an important part in that. Thank you.
Thank you so much, Professor Gerrard.